Yes, Shivani, over to you.
Yes. Good afternoon, everyone. I welcome you all to the day four
Shivani,
of the.
voice is very low. Voice
Okay.
is very low.
Uh, am I audible now, sir?
Uh, Still bit low.
Is it better now, sir?
Okay, no problem. Yeah, please go ahead.
Okay. Good afternoon, everyone. I welcome you all to the day four of the Faculty Development Program on ADR. Today's session will be addressed by none other than Mr. J Jawad on the topic Emerging Trend of Institutional Arbitration in India. It gives me immense pleasure to introduce Mr. A.J. Jawad, a seasoned legal expert, respected mediator, and a leading voice in the field of alternative dispute resolution in India. Mr. Jawad currently serves as the Registrar of the Indian International Arbitration and Mediation Center, Hyderabad. With over 30 years of legal practice, Mr. Jawad has had a distinguished career that spans litigation, arbitration, and mediation. He began his career as a practicing advocate and gradually carved a niche for himself in commercial and civil dispute resolution, especially in mediation, which has remained a passion and area of deep engagement. Over the years, he has conducted numerous mediation training workshops, facilitated court-annexed mediation programs, and worked with judiciaries, law schools, bar councils, and other ADR stakeholders across India. Prior to taking charge as registrar at IAMC Hyderabad, Mr. Jawad played a foundational role in building mediation ecosystem in southern India. He has served as a resource person for the Mediation and Conciliation Project Committee MCPC of the Supreme Court of India, training judges, lawyers, and faculty members on mediation techniques and ADR pedagogy. In addition to his institutional role, he is deeply committed to the legal education and has collaborated with multiple universities to embed ADR training in law curriculum. We are truly honored to have Mr. Javed join us for this faculty development program. His experience and vision will undoubtedly enrich our understanding of ADR not only as a procedural alternative but as a transformative approach to justice delivery. Please join me in warmly welcoming Mr. Javed. Over to you, sir.
Thank you very much, Shivani, for the very nice introduction. And thank you, Kalpesh, for this opportunity. And good afternoon and greetings to everyone who is here. I understand from Kalpesh that people in this group are from different walks of life, not necessarily legal professionals. So it would be very interesting to have this discussion with you because I'm sure that you will be able to look at this from a very neutral perspective, from a perspective that is not clouded by any bias or any prejudice as a legal professional. Uh, so one of the things that we need to start with, what I would like to emphasize is that, see, today we are in a very what should I say, a very peculiar situation, for want of a better word. In fact, it is a very dismal situation, if you ask me, because according to the last available statistics, we have about 5 crore cases that are pending all over India in different courts. And I read somewhere that according to Niti Aayog, it is going to take 345 years to dispose of all these cases, provided no new cases are filed. Now, where are we going wrong? And what do we need to do? Is it enough if we start, setting up more and more courts, more and more tribunals? We have the commercial court set up. We have various tribunals that deal with different kinds of disputes. Is that enough, or should we look at a paradigm shift in our thinking itself, in how we conceive the whole concept of dispute resolution? Now, that is where I'm coming from because I sincerely believe that I think we should uh, understand that the mistake that we have been making, if you can call it a mistake, or perhaps the lack of any other alternative is that we have conflated justice delivery with dispute resolution. So we have always tried to resolve disputes through an adjudicatory process, where by necessity you have to frame the problem, in definitions of rights and wrongs. So the whole problem is when you frame it in that kind of a model or a paradigm, it becomes a fault finding exercise because you have to necessarily prove the other person to be wrong to be able to get relief from the court. Now, in so far as disputes are concerned, now what do you mean by disputes? Disputes are essentially those problems that come up when people have different perspectives of what they should be doing in a particular relationship. Now, that relationship might be a contractual one, it might be a commercial one, it might be something, a family relationship. So, because of these different clash of perspectives, a dispute comes up, okay, a problem comes up. Now, to resolve that dispute, do we need the strong arm of law? Now, the problem is we have been going to the courts for every dispute. So, whether it is a matrimonial dispute, whether it is a commercial dispute, whether it is a contractual dispute, what has happened is we thought of some alternatives. We thought of arbitration. So, we brought in arbitration. But what happened was ultimately arbitration, also being an adjudicatory process, has gone back to the courts again. Because starting from the appointment of an arbitrator to the consideration of whether the award is right or wrong, an appeal against the award, all that has gone back to the courts. So it goes back to the court in the hands of the courts. It becomes a process where once again it goes back into mainstream litigation. So the very purpose or objective of having arbitration as an alternate dispute resolution process fails on account of that. Now, this is where I think we need to understand this essential difference that we have to stop looking at disputes from a fault finding paradigm, and we have to start looking at disputes from a problem solving paradigm. Now, why is there a problem between two parties? They might be juridical entities like two companies who have entered into maybe a joint venture, or it might be a contractual dispute between an employer and a contractor. It might be a dispute relating to a family business. It might be a dispute relating to husband and wife. It might relate to custody of children, whatever it is. It is a dispute which has arisen because people are looking at the issue from two different perspectives. So I have a perspective of what should be, done in these circumstances. You have a different perspective of what should be done, and we are in dispute. So now these are all disputes that can be negotiated and resolved. So if they can be negotiated and resolved, then definitely they don't have to go to the courts to get resolved. Now, why I'm saying this is because when you start, when the only course before you is to go to the courts, what happens is you have to fit the problem into the four corners of the law in order to be able to claim relief from the courts. Now, when you have to fit that dispute into the four corners of the law, you have to necessarily twist and distort whatever has happened between you and your adversary and give it a color of a violation of a right so that it entitles you to go to the court and claim or ask for the vindication of that right by applying the law. And there are complex procedures involved, and it goes on endlessly. And ultimately, what happens is whatever the relationship that is there gets completely destroyed because you have to prove the other person to be a bad person, to be a wicked person, or to be somebody who is, unscrupulous or who has cheated or defrauded you. So all these things you have to prove before the court in order to get a relief, whatever might be the dispute. Now, what we need to do today, according to my humble opinion, is that we need to start looking at disputes as requiring a different method of resolution, which should be moved away from the courts. The courts can supervise it to ensure that there is integrity, there is credibility of the process. But the courts should not, the necessity of going to the courts should not be there. So how do we go about doing that? How do we go about doing that? Because in order for us to bring about trust and confidence of the people in the process of dispute resolution, in order to implement an effective and efficacious method of dispute resolution, we need to, I don't know what this is, confirm your speaking language. Okay, I'm canceling. So we need to have a proper system of dispute resolution that would respect party autonomy, that would give the parties the choice of choosing an appropriate dispute resolution mechanism. It should be credible. Integrity and transparency should be assured. It should be cost effective, and it should be also time effective. It should be efficacious in terms of the time that is taken to resolve the dispute. Now, one of the ways that I would like to put before this August forum is to institutionalize dispute resolution. So we need to create an alternate ecosystem of dispute resolution which fits into all these categories or complies with or satisfies all these requirements of credibility, transparency, and efficiency. Now, how do we do that? How do we create these institutions? For which I would just like to share a small PowerPoint presentation. Actually, I like to ask a lot of questions in my talks, but I think there are too many people here, so it will not be feasible to put it in the form of an interactive session. So what I'll do is I'll make my presentation, I'll put my ideas in front of you, and then I would request you to ask whatever questions you feel are relevant to understand this better. I think that's all right, Kalpesh. Will that be okay? Follow that method?
Yes, yes. Yeah.
Yeah. So I'll just share a quick PowerPoint with all of you just to give you an idea of what I'm talking about. Okay. Are you able to see my PowerPoint? Hmm? Are you able to
Yes,
see
yes,
this?
yes, yes, yes. Yes.
Yes.
First slide.
Okay. So I'm now the Registrar and CEO of the International Arbitration Mediation Center. So what are we talking about right now? Because needless to say, courts are overburdened with disputes that actually do not require judicial determination. You don't need the courts to adjudicate all these disputes. These are all disputes that can be negotiated and settled between the parties. Now, the courts have recognized this, and that's why the courts are actively encouraging the use of alternate dispute resolution mechanisms like mediation and arbitration. I don't know how many of you know about the fact that in 2002, the Civil Procedure Code was amended to include section 89. And in that section 89, it was mandated to the courts to refer disputes to any of the ADR mechanisms that are mentioned in that section in case they see that there are elements of settlement. Now, this section was interpreted in a more expansive manner by the Supreme Court in 2010. And the Supreme Court said that referral to any of these alternate dispute resolution mechanisms like mediation, conciliation, arbitration is mandatory for the courts if the court sees an element of settlement. Now, how do you translate that element of settlement? It simply means, can this dispute or issue be negotiated between the parties and can it be resolved by an agreement that can be arrived at between the parties? If it can be done in that way, it does not require the courts to lay down a judicial precedent or to interpret a complex question of law or to deliver justice in the sense that there is an inequality between the parties. Like, for example, uh, some situations where injustice is done to people, so where the court has to necessarily intervene. So these are all cases which are exempted, but those cases which can be negotiated and resolved between the parties. Now this is where it does not require a judicial determination. The courts don't have to adjudicate the dispute. It can always be negotiated and resolved between the parties. So therefore, Section 89 was interpreted by the Supreme Court as a mandatory provision where the courts were expected to look at a dispute before them, look at the proceedings before them, form an opinion as to whether there is an element of settlement, and then refer it to any one of the dispute resolution processes that are mentioned in the section 89. If supposing the court chooses not to refer the matter, the court has to give reasons. If the court is referring, they don't have to give reasons. They just have to form an opinion that there is an element of settlement and refer the dispute. But if they don't refer the dispute, then they have to give reasons why they are not referring it to any of the ADR mechanisms. So the courts have realized how problematic it is to be called upon to resolve every dispute that comes before the courts, because most of these disputes do not require an adjudication or a decision by the court. So that is the situation as far as we are seeing today. Now the only thing is, we need to have the right framework where parties can resolve disputes without court intervention. Now what happens under section 89 is, you go to the court and then the court decides that, okay, please go for mediation or arbitration or whatever. But in case if we have the right kind of framework, parties do not even have to go to the courts. They can straight away come into this framework and make use of this framework to resolve the disputes without troubling the courts with this and without overburdening the courts, which already has happened. So most of the disputes escalate to litigation simply because we don't have a credible alternative dispute resolution mechanisms. So what kind of systems do we need to be able to prevent disputes from escalating to litigation? See, today, the concept of litigation, the court system that we have, is something that we inherited from our colonial masters. Okay, it's a good system. It has been functioning very well. And though there have been challenges, it is overburdened today. But it is overburdened today because we have not looked at alternatives. We have not thought of doing things in a different way. We have simply blindly, we are just following a system that was given to us, thinking that that is the only way that in which we can resolve disputes. Now, I always quote this Zen saying, which says that when the only tool that you have in your hand is the hammer, every problem looks like a nail. So today, unfortunately, what has happened is, today our legal professionals are trained only in the adversarial method of dispute resolution. So I'll just give you a small story which I always share to show how the way the system has worked and how unfortunate it is that today we are looking only at the courts for resolving every dispute that comes up. There was a lady who came to me many years back saying that I want a divorce. And I said, fine, so what happened between you and your husband? Why do you want a divorce? And she told me her story. And I made my notes. Now, I told her, you please come back after 2 days, I'll have the petition ready. Now, I went through my notes and I realized that it was not a case where I could really make out grounds of cruelty or desertion or whatever the other things that the law requires for me to prove in order to entitle her to get a divorce. So what I decided to do was that I decided that, okay, I have to make out a case uh, in such a way that she gets her divorce. So I prepared the petition, okay? And whatever the facts that were given to me, I appropriately changed them in a manner that would, in the right framework that the law requires it to be, so that I can prove that she has been treated with cruelty. Now she comes back and reads this, and she starts crying. And I asked her, why are you crying? And she says, I didn't know that I had suffered so much. So you see what is happening actually. It's not just in matrimonial disputes, even in contractual disputes, even in commercial disputes. The whole legal framework is such that we have to prove the other person to be wrong. And that escalates the dispute. Okay, and that is where the litigation gets escalated. And we all know, I'm sure, though most of you are not lawyers, I'm sure you know how the court process works and the kind of time that it takes for disputes to get resolved. So when I'm talking about courts taking up only those cases where justice needs to be delivered, let me give you a couple of examples for you to explain to you what I mean by this. There was a case in 2023, there was a report that father and son who were convicted 25 years ago for having committed a murder were finally found to be not guilty and they were acquitted. and they walked free. But the problem was only the father could get out of jail because the son had already died. An offense that they had not committed, which ultimately the Supreme Court found that they were not guilty. There was no case against them. That was the Supreme Court's finding, but they had already spent 25 years of their lives. Now, this is where justice is required to be done. A man was convicted for having committed a murder at the age of 45, and the conviction came when he was 90, 45 years later. So, where is the justice here? So, the courts don't have time to render justice because they are resolving these disputes. They are deciding how father and son should divide the property, or how two companies should terminate their contract, or what kind of compensation has to be paid by one person to the other. So why should the court spend their time doing that? Why can't we have an alternate mechanism, a dispute resolution mechanism by which people can get easy access to justice, right? Now, the current system depends largely on litigation because that is the default pathway. So even for disputes that could be resolved through alternative means, obviously, because the courts typically step in, you go to the court only after the dispute has escalated beyond the possibility of resolution. And therefore, there is a delay in the judicial intervention. Now, the legislature, introduced Section 12A in the Commercial Courts Act. Now, if many of you may not know what commercial courts are, commercial courts were set up under an act which said that all commercial disputes should not come to the regular courts but should go to the commercial courts. So courts were designated as commercial courts and disputes were referred to these commercial courts. And the law was in 2016, again, the law was amended, that particular act was amended to introduce Section 12A, which said that before you invoke the jurisdiction of the criminal court, of the commercial court, you have to go for mediation. So before you come to the court, you have to go for mediation. But what happened was there were three problems in that. One, it said that if you need an urgent interim order, you don't have to go for mediation, you can come directly to the court. Now, lawyers are very clever in framing interim orders. Okay, they somehow explain how urgent it is to get either an order of injunction or an order of stay or some kind of a relief or the other. So many cases bypass this and then they would go to the commercial court without going for mediation. Then finally, the Supreme Court woke up to this fact and they said that it cannot be an illusory claim for interim relief. It has to be a genuine one. Otherwise, your whole suit can be rejected by the court. So that was the finding given by that was the judgment delivered by the Supreme Court. The second loophole was that if the other side does not respond, you send an invitation to the other side saying, look, we have a dispute, please come for mediation. And the other side doesn't reply to you, then you can come to the court. Okay, now there was no penalty on the other side for not responding to a reasonable request for mediation. So that was one loophole. The third loophole was that the entire administration of that mediation was given to the National Legal Services Authority. Now, the objective with which the National Legal Services Authority was established was to provide legal aid to people who cannot afford to go to the courts. And this is beyond the scope of what is called as NALSA, the abbreviation, National Legal Services Authority, or the State Legal Services Authority. Their scope is something different. But this burden was put upon them. And the NALSA was given the responsibility of conducting mediations. So obviously, there were a lot of challenges in this, so it could not be really effective. So the whole problem is today, we don't have a robust institutional framework for early resolution, which results in matters unnecessarily entering the court system. So what we need today is a robust and credible institutional framework. So why courts can't be default options? See, the court-centric model, as I said earlier, prioritizes adjudication over resolution. So we are not talking about problem solving, we are talking about problem inflaming. So we are talking about an adversarial process. We are talking about a fault-finding paradigm where you have to prove or find fault in the other person in order to be able to claim any relief before the courts. But what we really need is not an adjudicatory or an adversarial or a fault-finding process, but we need a problem-solving approach. So you and I have a problem. Let's sit across the table and let's talk about it. with the help of a neutral third party. Okay, and who should be the third party, how that process should be structured, and if supposing we are not able to resolve, what should be the next step that we should take? Should we go back to the court, or should we have an agreement that we will go for a forum that would be able to adjudicate the dispute between us? Now, the second point is that today, there's a lot of expertise that is required because the disputes are sector specific. So you have construction disputes, you have tech disputes, you have media disputes, you have intellectual property disputes. So instead of more courts, what we need today is a leaner, faster, specialized institutional mechanism that without duplicating the judicial infrastructure. So that is how IAMC is structured. I'll come to that later on, because we are going to be talking about what are these emerging trends that we are seeing today happening. Because this is happening all over the world, and we'll talk about that also. Now, usually the court timelines are often prolonged due to procedural rigor because the whole litigation process is very rigorous. It is completely procedure driven. So even if you want, for example, an adjournment, you have to file an application for that. And the other side will be asked to file a counter to that. And then the court will decide whether to give you an adjournment or not. If you want to find some additional document before the court, again, the same rigorous process is followed. So this leads to unnecessary prolongation of the whole case and extra costs. And we all know the saying, justice delayed is justice denied. Okay. So what are the disputes that can be resolved through this dispute resolution mechanism? Civil disputes. Okay, essentially disputes that arise out of civil cases like maybe partition disputes or any other kind of civil dispute, contractual disputes, because parties enter into a contract and then they enter into a situation where they have a dispute about how the contract should be understood or what should be the obligations of each of the parties. Then we have commercial disputes where commercial transactions take place between people and these lead to disputes. Then we have family disputes, which might be matrimonial disputes, which might be even family business disputes. So all these disputes are, which are those disputes that can be resolved as they have to be regarded as disputes that need to be resolved from a problem solving perspective rather than from a fault finding perspective. So what we really need, what kind of institutions should be built? And this is not, I'm not talking from the air about this. This is how other jurisdictions have developed their institutions. We have several institutions like this. For example, we have the Singapore International Arbitration Center. We have the Singapore International Mediation Center. We have the London International Arbitration Center. Dubai is doing a lot of work in setting up this. They have set up the DIFC, the courts that use arbitration and mediation to resolve disputes. We see this everywhere in the world. Okay, this is happening all over the world. So it is high time that we also follow. So basically, because these institutions cannot see, they need infrastructure, they need technology, and it's very difficult for private people to invest that kind of money in setting up that kind of infrastructure. So state funding becomes absolutely necessary because without the funding of the state, it cannot be done. Okay, you need a lot of expenses required, and the day-to-day running, the operational costs, because these kind of institutions do not start making money, and they are not established with the profit motive. They are established with the objective of providing a credible mechanism. Now, the second thing is they should be judicially supervised because the court should not interfere in the day-to-day management, but the court should overall supervise how, because somewhere you have to account for the credibility and the accountability have to be ensured. So people need to trust the institution. The third thing is they should be autonomously managed by experts in dispute resolution. So it cannot be left to people who are either, you can't just leave it to people who have no experience in dispute resolution, who are not trained mediators or trained arbitrators, who have no idea about how this should be handled. So these are the three things that are required. Now, IAMC is one of the example because IAMC is one of those institutions that are actually trendsetters in the field of dispute resolution. It was set up with the support from the state of Telangana. It is fully funded by the state of Telangana. It is supervised by a board of trustees to ensure the integrity, but free to operate professionally. So the trustees are retired Supreme Court judges of impeccable credentials, and they supervise or they take whatever the policy decisions that have to be taken. So the secretariat goes to them only whenever there is the requirement for taking any policy decisions regarding some big expenditure or conducting some big event. Otherwise, it is professionally managed. Okay, and this provides a very credible alternative to courts because there is a total autonomous management of this institution. Now, how the process works. So supposing you, let's say that, you have a contract and you want to refer a dispute that arises from the contract to an institution. Now, how the process works is, or you may have a clause in the contract which says that if any dispute arises, it will be referred to so and so institution. Now, what happens if a dispute arises is, it is referred to, for example, the IAMC. A request is sent by one of the parties to the IAMC. The IAMC writes to the other party and says that we have received this request from party A, and they want to go in for resolving this dispute. So we would like to be appointed a mediator for this. So here is a choice of mediators. Both of you can agree on who should be the mediator. And if you're unable to agree, we will appoint the mediator from our side. So what we do is we are aggressively promoting the med-arb concept because that is one of the things that, one of the emerging trends throughout the world, which we are seeing is the use of hybrid methods like mediation and arbitration. Now, the advantage of this method, what is called as the med-arb method, is that when you go for mediation, there is every possibility that the dispute may get resolved through the process of mediation because there is a neutral, trained expert mediator who's sitting there who helps both parties to negotiate with each other and come to a conclusion that is acceptable to them. Now, direct negotiation is very difficult because people are usually angry with each other. There might be trust issues between the parties. There might be communication issues between the parties. So the mediator is able to facilitate the proper communication, build up the trust and confidence between the parties, helps them to look at alternatives, helps them to take, examine what their best alternative is to a negotiated agreement, and does a reality check, plays the devil's advocate with the parties, helps them to understand what is in their best interest to do. So invariably, what happens is in the mediation process, in the hands of an expert mediator, the dispute gets resolved. Now, what happens if the dispute does not get resolved? So what happens if the dispute gets resolved, there is a settlement reached, okay, that you can see at the bottom of the page. It is certified by the institution. And now under the Mediation Act, I don't know how many of you know about the Mediation Act. In 2023, the Parliament passed an act which they called as the Mediation Act of 2023. Okay, but unfortunately, the government has not notified this act. It also contemplates the formation of a Mediation Council of India, which would be governing mediation, which would be certifying mediators, which would be prescribing standards. So all these things need to be done. But what the Act says, what is very important is that for us is to understand that the Act says that if parties reach a settlement through the mediation process, that is deemed to be a decree of the court. So if supposing one party defaults, the other party can directly go to the court and execute the decree. Okay, so you don't have to file a de novo suit and try to prove the claim and then get a decree from the court and then execute the decree. You can straight away go for execution of the decree. So it is deemed to be a decree of the court. Now, what happens if the settlement is not reached? Now, because it is a med-arb, it's a hybrid process that you have chosen, the IAMC appoints an expert arbitrator. So how do you appoint that? IMC gives a choice to the parties to choose an arbitrator from their panel, either one arbitrator or three arbitrators. So if the parties are able to agree upon a bilateral choice is made by them unanimously, if they choose, that's fine. That person is appointed as the arbitrator. because the institution maintains a list of a panel of arbitrators who are specially trained in sector-specific arbitrations. Okay, for example, if there is a construction dispute, then you appoint an arbitrator who's been specially trained to deal with construction disputes. Okay, so if it is a technological issue that comes up, maybe pertaining to data privacy or whatever, then the arbitrator is chosen who has an expertise in that. So also the mediator. So mediators are also trained in these sector-specific issues. Okay, so once the arbitrator is appointed, the arbitration proceedings take place. The arbitrator gives the final award, and the final award is scrutinized and issued by the institution. Now, how is this process different through the institutional framework as compared to a dispute that is referred to arbitration where there is no institutional clause? So you have not named an institution in your contract. Now, how do you deal with that? Now, there, what happens is it is called as ad hoc arbitration. So it is different from institutional arbitration. Ad hoc arbitration is where you have not named an institution. Your clause simply says that if there is a dispute, it will be referred to arbitration. Now, invariably, what happens is when the dispute arises, when one party writes to the other party saying that I want to go for arbitration, we have a dispute, and please agree for the appointment of an arbitrator. Either the other party disputes that or they don't agree for the appointment of the arbitrator that is chosen by one party. So both of them are not able to reach an agreement. They don't have a mechanism by which somebody else can, there is no institution that can appoint an arbitrator. So they go under Section 11 of the Arbitration Conciliation Act to the court. Now, when you go to the court for appointment of arbitrator, the fastest that this can be done is 3 months. And it takes even up to 2 years to get simply an arbitrator appointed or an arbitral tribunal to be constituted. So 2 to 3 years is taken up just for the appointment of arbitrator. Now, the other part of it is that in the absence of, in these ad hoc arbitrations, there is nobody who manages the case. The entire job of case management is left to the arbitrators, the arbitral tribunal, and the lawyers of the parties. So what happens? Scheduling of hearings, exchange of documents, conducting the process, all these become problematic because it all depends upon how much consensus is able to be reached between all these stakeholders who are involved in the dispute. Whereas in an institutional setup, the advantage is that the entire case is managed by case managers who are specially trained for this purpose and who deal with this case from the time the notice is issued up to the time the award is passed or the settlement is reached. So there are case managers. For example, in IAMC, we have case managers who handle the entire case. And we are now implementing software, an ODR platform, which would be in which there would be a dashboard provided to all those who are involved in a particular case. They can access, upload documents there. Those documents will be accessible to all who are involved in the case. There is total confidentiality that is assured. Scheduling of hearings takes place by the the case managers. Exchange of correspondence, all this is facilitated by the case managers. All the follow-up, fixing the dates, scheduling the hearings, and being present at the hearings and facilitating the smooth conduct of those hearings, everything is done by the case managers. Whereas in an ad hoc arbitration, you don't have any of those facilities. Okay. Now, what are the advantages? Obviously, as I told you, one, it is time efficient. There is end-to-end case management. There is minimal or reduced court intervention. It is only if you are aggrieved by the award, you go to challenge the award. But what happens in an institutional setup is that the awards, once passed by the arbitrators, are scrutinized by the institution to ensure that they comply with all the legal formalities, all the legal requirements. Any mistakes in the award, we request the arbitrators to correct the award. If supposing the arbitrators have not given reasons for any particular findings, they're asked to fulfill that lacuna also. So the scope for challenge is substantially reduced. Okay, and having gone through the process of mediation, even the scope of the dispute is substantially narrowed because parties have a clear idea as to where they stand with regard to their claims. So not all claims may be going for arbitration. So there is efficiency, and there is a timely disposal. Okay. There are expert panels because in ad hoc arbitrations, you're not sometimes able to appoint somebody who's an expert, either as a mediator or as an arbitrator. And we have rules, okay, clear-cut rules are there, which tell you that what you can expect and what you need to do, how the process should be conducted. There is absolute transparency of the cost, because in ad hoc arbitrations, there's no control over the costs. Okay, it is whatever the arbitrators fix the fee, and that you have to necessarily pay. And none of the arbitrators actually follow the Schedule 4 of the Arbitration Act in terms of fixing the fee. Whereas in an institutional framework, nobody can demand a higher fee than what is already prescribed under the institutional rules. Okay, and there is a focus on the real issues. There is a possibility of a collaborative outcome because you're going for mediation first, and there's every possibility that your dispute may get resolved. There are flexible entry points. It preserves the relationships. And most important is that today, the unfortunate situation is because of the absence of credible institutionally managed dispute resolution methods, even two Indian companies who enter into a contract in India choose to go to either Singapore or London or Dubai for resolving the disputes. That is the unfortunate situation. And that is why we need the institutional framework to resolve the disputes. And in fact, we are advocating that every state should establish an institution like the IAMC. The central government has established the Indian Institute, India International Arbitration Center in Delhi. There is a mediation, there is a Mumbai Center for International Arbitration in Bombay. So there are institutions like this which are established, which support, which make this process easy. Unfortunately, many of these institutions focus only on arbitration, whereas in IAMC we focus both on mediation and arbitration. So we are promoting the med-arb method of dispute resolution, and we are urging the companies and corporates and other stakeholders to have clauses in their contracts that promote mediation and arbitration through the institutional framework. So what happens if you have a clause in the contract which says that if the dispute arises, it will be referred to so and so institutions. It becomes easier because you don't have to necessarily keep corresponding with the other side and wait for the other side to agree or disagree, or go to the court to get a mediator or arbitrator appointed. You can simply come to the institution, hand over the job to the institution, and the institution takes care of the rest of the things. Okay. Now, there are model clauses. How do you access the institutional service, for example, of IAMC? You can include the model arbitration or mediation clauses while drafting a commercial contracts, ensuring automatic referral to IAMC in the event of a dispute. You can, even in the absence of a clause, you can submit your dispute to IAMC. So upon such request, IAMC will administer the mediation of arbitration proceedings according to its rules. Now, where a dispute resolution clause exists but does not mention any specific institution, you can approach the court under Section 11 and ask the dispute to be referred to IAMC. Now, one of the advantages of getting the dispute referred to IAMC, an institution like IAMC, is that you have all the infrastructure. Normally, arbitrations or mediations take place, mostly court-annexed mediations take place within the court campus. But if you want to go for a private mediation, you have to either book some five-star hotel or you have to book some other venue, and you incur a lot of cost for the venue also. Whereas if you refer the dispute to an institution like the IAMC, we have world-class, infrastructural facilities here. We have well-appointed mediation rooms. We have which are designated, which are designed in such a way that in on par with any global standards. You have arbitration halls where multi-party arbitrations can be conducted with the scope for seating a large number of people. We have all the facilities for transcription. We have the facilities for recording of evidence. We have the facilities for, the conduct of the arbitration, whatever the case management requirement is there, everything is there. So what the parties can do is they may mutually agree to, approach IAMC. Now, if one party doesn't agree, the other party can go for Section 11 and ask the dispute to be referred to IAMC. Or if both of them agree, you can straight away come to IAMC, which can administer the matter in accordance with the relevant clause. Okay. Now we have the fee structure, which is a very transparent fee structure. This is what it is. You can access this on our website also. So the arbitration fee is there. For domestic arbitration, we have one fee schedule and another fee schedule for international arbitrations. And this is how the infrastructure looks. Now, what you see on your right side on top is the mediation hall. There's a conference hall on the left side. We have breakout rooms where during the course of the arbitration, parties and lawyers want to take a break to discuss any strategies or anything. They can always go there. We have video conferencing areas and we have the arbitration halls. So I'll just stop the slide share here. So if you look at what the global scenario today is, today the world is looking to these kind of methods. You have the New York Convention, which facilitates the enforcement of arbitral awards passed in member countries in the other country. You have the Singapore Convention, where mediated settlement agreements can be enforced. When settlement agreement is reached in one country, it can be enforced in another country if it is a signatory to the Singapore Convention. So if you see the emerging trends that are there, and then there is online dispute resolution. And, you know, mediation and arbitration are actually very conveniently can be done through the ODR mechanisms. So we have ODR platforms. So we organize the meetings either on Zoom or on WebEx and enable the parties to resolve the disputes through the online dispute resolution mechanisms. So we all know the advantage of the online dispute resolution mechanism. It is time agnostic, it is space agnostic. So you don't need a specific venue for that. Uh, so the whole administration is done by the institution within the rules framework of the rules. So this ensures credibility, this ensures transparency, this ensures efficacy, it ensures efficiency, and also ensures cost effectiveness. So considering all these facts, the emerging trend today, as we can see, is towards institutional ADR, which is basically appropriate dispute resolution, which is mediation and arbitration. So this is the trend that we are seeing all over the world, and in India, we are also trying to promote this concept as aggressively as we can through conducting events, through conducting awareness programs. We are organizing roundtable conferences for different stakeholders. And in IAMC, we are not just focusing on the commercial part, we are also focusing on the social and community part. So we are conducting training programs for mediators to deal with, for social workers and NGOs that deal with actual day-to-day matrimonial disputes, family disputes. So we are focusing on all these things. So the idea is to make India as the hub of mediation and arbitration, because today India stands very low in the order of preference of parties choosing to come to India for resolving the disputes. So what we are trying to do is we are trying to set up this kind of an institutional framework, which, if you compare the costs, for example, the administration fee that we charge at the IMC is only a fraction of what the Singapore International Arbitration Center charges. So with these advantages, we are hoping that, very soon, India will become the hub of dispute resolution. So it is not just, commercial disputes, because as we all know, that, when we talk of ease of doing business, one of the integral factors that promote ease of doing business is ease of dispute resolution. So when you are able to provide an institutional framework of this kind, which ensures effective and efficient dispute resolution in a credible and in a trustworthy manner, you're going to be attracting foreign investments also. So it is good for the economy of the country. And you will be surprised if I tell you, many of you may not know about this, that the cost of pendency of litigation for long periods of time is costing us almost 2% to 3% of our GDP every year. This is the economic loss that is being caused to the country because of the delay in dispute resolution. So the way forward, how I see it and how we all should see it, is that we need to strengthen the institutional framework by following the methods that I have highlighted here. And this would help us to deal with the backlog of cases, with the challenges that we face. After all, ease of dispute resolution means access to justice also. So you're freeing up the courts to render justice where the justice is due. So I'll stop here and I would be happy to welcome any questions from you. You can just raise your hand, a digital hand, and ask the question. Please switch on your video. When you're asking the question, unmute your mic. Is that okay, Kalpi?
Yes, yes. I'm just, participant, you can start your video, unmute yourself if you want to ask any question. Yes, you can raise your hand, participants, or you can unmute yourself.
Looks like there are no questions. Now I
Sir,
get
I
into
have a
the
question.
yes, sir,
Okay.
Shivani. Thank you, Shivani, because I get very nervous when there are no questions. Because it means that I have spoken so much of nonsense that people don't feel like asking for any clarification.
Sir, my question, like I've always seen that in Europe or US, um, the litigators actually get a cut when they mediate,
Mm,
but that is not allowed in India.
yeah,
And that is why a lot of lawyers discourage their clients. I've seen it
mm,
firsthand as well, that they
yeah,
discourage their client from
yeah,
settling down.
yeah.
So, what can be done in that regard?
See, when we are talking about a systemic change, Shivani, I think we need to relook at all these because, see, in our country, we followed the British system of Champerty, where, having a stake in the outcome in terms of percentage of whatever the legal success that you get is looked down upon and it's regarded as Champerty. Whereas in countries like the US, it's a normal thing to do. Okay. Now, when we talk about creating a method of institutional framework of dispute resolution, see this will actually what it means for lawyers. I'll tell you. For lawyers, it means number one, job satisfaction. You talk to any lawyer today, regardless of the fees that they earn out of their case, invariably 99.9% of the lawyers say that we are not satisfied with the work we are doing, simply because they go with an expectation to the court, but that expectation is never realized. And I have practiced law for more than 25 years before I jumped full time into mediation. And I have been in mediation for the past more than 12 years exclusively. But what I have seen even as a lawyer is even when you win a case, a client is not satisfied simply because the client did not get what he or she wanted. Okay, so you are not able to ensure client satisfaction. You're not able to solve the problem of your client. You're trained to become a problem inflamer. Unfortunately, a legal curriculum only promotes legal, problem inflaming, like how I did in that matrimonial case that I mentioned. I inflamed the problem instead of solving the problem. Now, that is why we need a credible alternate system where, through an institutional framework, we're able to resolve disputes effectively. And when you're looking at that framework, I think even the concept of what the legal fees should be, because lawyers, when they are assisting parties in mediation, they're not litigating. Okay. They are not following an adversarial method. So what happens sometimes the clients don't see the value of what the lawyer is bringing to the table in a mediation. So therefore, I think that awareness has to be created first. Okay, and there should be clarity, and lawyers should be permitted to charge an appropriate fee for what service they are rendering, even as lawyers who are representing parties in a mediation. And we are doing mediation advocacy training because you need a different frame of mind to be able to assist a client in mediation. So you have to fix a fee for that. And it will only mean that your credibility increases, your client's trust in you increases, and you're expanding your portfolio. Okay, so it means more earnings. Now I read somewhere again, Niti Aayog says in one of the ODR, papers that they published that 3% of disputes alone come to courts. What happens to the 97%? Where do they go? How do parties resolve those disputes? Right? So you're expanding your portfolio when you offer. Why don't they come? Is because they don't trust the system. Okay, they don't have the patience, they don't have the money to spend, they don't have the resources to spend. and that too on a gamble. They don't know what the outcome is going to be. So you are giving them a more assured, outcome for dispute resolution. You're helping them to build better relationships. You're helping them to find solutions to their problems that would be long lasting, in the sense that there would be an element of finality to those. So all these are factors that go to say that lawyers will be the biggest uh, you know biggest beneficiaries of this institutional mechanism.
A couple of questions in the chat box. Do academicians have any way after training to work as a mediator?
Well, definitely. See, once the Mediation Act comes into force, that will be a game changer. Because the Mediation Act nowhere says that only lawyers can be mediators. So any professional can be a mediator. So anybody who can get trained in mediation can be mediators. So basically, there is a lot of what I call mediation is that it humanizes the conflict, because it recognizes that people are in conflict because of the way they perceive the situation, not generally because they are bad or good people. Okay, so you're able to handle the people, you're able to find solutions for them, help them to find their own solutions. Uh, you don't need a special knowledge of law for that. Okay, but sometimes if it might be a sector specific dispute, like for example, if it is a dispute that relates to some legal relationship and what kind of an outcome that should be there, you can always consult lawyers in that. Okay, you can even co-mediate with the lawyer who knows the legal aspects of it. So there are infinite possibilities when it comes to others also getting into the field of dispute resolution. And mediation training itself, if you get trained in a proper way with a proper institution, it can change your life, because it changes the whole perspective of how you look at life, how you deal with relationships, your own relationships, how you communicate, because communication skills, problem solving skills, how to handle people, how to handle your own emotions, all these things are trained. You're trained in all this when you want to go the mediation training. What is the next question?
For question, we can take up the role of technology in resolving dispute. What we are
I think
yeah.
one more question is there. My doubt is that how it can reach the people within India, as it is developing country with a lot of contradictions. Well, see, we have been giving this excuse for a very long time, saying we are overpopulated. That's why we have problems. We are a developing country. We have, see, unless and until we wake up and we take the bull by the horns, and unless we recognize the problem and start dealing with it, I don't think we'll go on. See, we are now almost 8 decades through independence, and it is time for us to have a relook at our systems and to see whether what we need to do to go forward. So I think it needs a collective effort. It needs a lot of effort from all of you as stakeholders in society to create this kind of an awareness among people. Okay, so we are taking a lot of initiatives. Okay, we are conducting awareness programs. The Supreme Court itself, through the Mediation Conciliation Project Committee, recently launched the Mediation for the Nation initiative. So all these things are happening. We need to do something more, which each one of us should take the responsibility of spreading the message. What role technology can play? Well, technology can play a huge role, because see, one of the biggest advantages of online dispute resolution is, as I told you already, that it is time and space agnostic. And pre-COVID, I used to do mediations in the court. So just to give you an example of how it works, I used to go 25 kilometers driving to the court. Sometimes the parties don't come, or they have some issues, they have some problems, they don't turn up. Some parties get delayed, so my whole day used to get wasted. Now, after COVID, one of the mixed blessings of that was the fact that we discovered the advantages of Zoom and WebEx, etc. So what I started doing was I started doing online mediations, and the response was excellent, and the process works beautifully. So you can reach out to people different, sitting in different. I have mediated disputes with parties, somebody sitting in the US, somebody sitting in India, somebody sitting in Singapore. So I'm sitting there in my pajamas with a coat on top and mediating a dispute at 12 o'clock in the night, right? So parties are in different parts of the world. So it can be done. So that is the advantage of it. You don't need space. It is cost effective, and you don't need to travel to different places to be able to participate or in the proceedings. So all these advantages are there. So Kalpana has asked some question. Due to technical constraint, couldn't on the video. However, I'm curious to know about the recent case related to the land allotment for IAMC, given the washing of all the matter we referred to. Okay, this is actually not relevant to the topic, but nevertheless, I will answer the question. See, only the land allocation on procedural, on technicalities, the court has set aside the allotment. Of course, we are challenging that. But the establishment of IAMC has been upheld. Government support has been upheld by the court. Okay, and the court has said that the government has not done anything wrong in supporting an institution like this. So there's no problem with that. Whether in the case of foreign award, which convention now India has followed, is that the New York Convention or Geneva Convention? That depends on the context of the matter. Mostly it is the Geneva Convention. Please suggest best institute in India to get trained. IMC itself is offering training. You can follow a LinkedIn page and also a website. In September, we are conducting a training in collaboration with the UK-based organization, which is mediation training. And in November, we are planning an international arbitration training. And in January or February, we are doing a sector-specific arbitration training for uh, that is construction arbitrators working in the built environment. And we did a course recently for women in arbitration because women are hardly represented as arbitrators. So we wanted to give them that window of opportunity. So we conducted a training, and 19 out of 28 people qualified, and they have been empaneled. And we are referring disputes to them for arbitration.
Sir, sorry, sir, what's for, so,
Yeah, just one last
yes,
question. I'll answer Piyush Kumar's question, which says that,
yes.
yeah, how to get, as I told you already, we are doing the arbitration and mediation trainings now. So we are focusing on the capacity building so that we can have the panels of mediators and arbitrators, especially those with sector-specific expertise. We're focusing on that. Yeah, I think that's it. Thank you very much for patiently listening, and I'm so glad that so many questions were asked.
Somebody had to start, so and then people started asking questions. So thank you very much, sir, for your great insight. Again, good to see you second time after GNLU meeting. So, sir, for insightful session. And then again, a lot of things have to be done in this, area, and more like, practical aspects is needed. It's the law school level, because again, we are teaching that, BARACT, Arbitration Concession Act, and now Mediation Act. So more and more
For
practicalities,
you,
sorry, no
but
more question, please. Sorry, sir, we are not taking any more questions. So thank you very much, sir, once again on behalf of the housing committee. We are grateful for your valuable time and sir insights. Look forward to seeing future programs also. Thank you very much.
Thank you everyone for patient listening, and thank you once again, Kalpesh, for the opportunity.
Thank you. Thank you, Shivani, and thank you, participants, for joining. See you tomorrow.
On behalf of the organizers and all the participants of this faculty development program, I take this opportunity to extend our heartfelt gratitude to Mr. Javed. Thank you once again, sir, for enriching this FDP with your knowledge and for contribute to meaningfully to the field of ADR in our own capacities.